Okay, so I just want to put on the record what was happening sort of logistically at sidebar. I was having a discussion with the attorneys because some things that have been requested by the Commonwealth might be objected to by defense counsel. And I had to make some preliminary rulings and make some preliminary guidance about what I thought about that. Obviously, if there's something that's objectionable or isn't supposed to come into evidence, I can't have it discussed in open court when it shouldn't have come into evidence. I want it to be very clear. Everything that was said on sidebar was recorded on our recording system. It is available to the public. It is available to the media. It is not impounded. But that was necessary to make some preliminary thoughts about what could and couldn't be discussed. Public has some right to information. The defendants have some right to object to some information becoming public at this point. We're trying to manage the case appropriately. So that's what it's about. Everything is on the record and can be listened to later. All right, but I don't know what I'm going to hear until I hear it. All right, let's proceed.
Thank you, Your Honor. I had, on behalf of the Commonwealth, suggested to the clerk's office that it was my intention to file certain documents with Your Honor. And if I might, those documents are the Commonwealth's statement of the case, the Commonwealth's notice of discovery, the Commonwealth's motion for fair and reasonable bail, the Commonwealth's motion for a protective order together with a proposed order, and the Commonwealth's preliminary statement in accordance with General Laws, Chapter 276, Section 56A. Respectfully, Your Honor, those items, to the extent that Your Honor approves of their filing, speak for themselves. With respect to the Commonwealth's motion for fair and reasonable bail, the motion as filed requests for, strike that, I apologize, requests on behalf of the Commonwealth that the defendants be released on personal recognizance. There are three additional requests. The first of those three additional requests is that the defendant shall refrain from participating in any manner in any training activities involving boxing and or any similar, quote, physical confrontation exercises, whether as a supervisor, instructor, teacher, coach, or otherwise. Given the conversation that was recorded at sidebar, I'm asking the court to take no action on that second request, or if the court prefers, I will affirmatively withdraw that request. The third request in the Commonwealth's motion for fair and reasonable bail is that the defendant shall have no contact, direct or indirect, with any of the potential witnesses in the case. The Commonwealth will provide the court and counsel for the defendants with a list of such witnesses. The list shall be impounded and shall be subject to the general protective order that the Commonwealth asked the court to issue this day. As I stated in the recorded conversation with counsel in the court at sidebar, the basis in large part for that request are the facts and circumstances of this case as described in the Commonwealth statement of the case. The fourth and final request in the Commonwealth's motion for fair and reasonable bail is that each of the defendants surrender any and all firearms in their possession, custody, or control. And is the case with item number 2 of the Commonwealth's request, given the conversation at sidebar with counsel in the court, on behalf of the Commonwealth, I would ask that the court at this time take no action on that request as well. With respect to the Commonwealth's motion for a protective order, for the reasons set forth in the facts and circumstances which are articulated in the Commonwealth statement of the case, I would respectfully suggest to the court that the motion and the proposed order are fair, reasonable, and appropriate given the circumstances of this case. Thank you.
All right, thank you. So just to elucidate a little bit what's going on at sidebar, counsel for the defendants, or at least some of not binding, it won't be admitted at trial. It's simply an outline of what's happened sort of so far and an explanation of the Commonwealth's reasons for going forward. So it is not filed in every case, but this is a case of high public interest. And so I have allowed that document to be admitted over objections of defense counsel. With regard to the Commonwealth's motion to admit defendants to fair and reasonable bail, Attorney Meyer just went over that. I have indicated at sidebar, and I'm indicating again on the record, I will not impose condition number 2. The defendant shall refrain from participating in any manner in any training activities involving boxing and or similar physical confrontation exercises, whether as a supervisor, instructor, teacher, coach, or otherwise. Bail is to ensure that the defendants will appear in court. This is not a dangerousness hearing. That is a separate statute, Chapter 27658A. The defendants are not charged with being dangerous. My abilities to impose conditions of bail are limited in a routine bail case like this. And so that has nothing to do with them appearing here in court, and I would not impose it. Condition number 4 says the defendant shall surrender any and all firearms in their possession, custody, or control. I am not the licensing authority. I do not control who has or does not have a firearm. It is not a domestic violence case. It is not what we call a dangerousness case. Chapter 276, Section 58A. This court is not the licensing authority. I don't believe I have the authority to impose that condition. There are Second Amendment issues, and so I will not impose it. Those discussions were had at sidebar. I will hear from counsel about the motion for the appropriate protective order. I did indicate generally that I was inclined to impose it, but counsel may have objections they want to put on the record in open court. Any order I make regarding the protective order will be, at this point, only not binding for further decisions as the case plays out. There may be reasons to modify that protective order, but we can't foresee the entire future at the short arraignment proceeding. All right, I don't know who wishes to address the court first on behalf of the defendants.
Your Honor, on behalf of Lieutenant Denton, with regard to the protective order. This particular case, the protective order, in our opinion, in terms of the restrictions that are imposed on what we can show our clients and how we can show it, and other aspects, are unduly burdensome, unnecessary, and respectfully inappropriate. This is not a case where witnesses have been intimidated. This is not an organized crime case involving the Cosa Nostra. This is a case in which we have voluminous discovery. To say that our clients may not have the discovery themselves and can't be trusted with it, we must keep our law offices. From a practical purpose, likely with the volume of materials, result in them having to come to our office virtually every day for the next year. That's impractical, it's unwieldy, and it's wholly restrictive of the attorney-client relationship. Also, all of us here are experienced lawyers across the board here. We understand how attorneys are restricted with personal identifying information and materials on that. We are all familiar and experienced with handling grand jury materials and placing those materials under seal when we attach them to documents. And so I think that the protective order is so restrictive as to be completely hamstringing, and also it paints our clients in a manner that's not consistent with this particular case.
All right, thank you. Attorney Reddington, do you wish to
I
hear?
would just echo what my co-counsel has stated. These are good people. These are good people. These are not people that are violent. They're not, certainly, as we would say, mafia, going to threaten people or get some or glean some facts from the discovery and use that to intimidate people. I don't see that as even remotely possible. I agree that it is very onerous. I've been through the dealings with the protective orders. It's horrible. I mean, people cannot get their access to their own discovery. They have to come to the attorney's office, as I said, sit down and look. It's very, very restrictive, and I think it's somewhat, when you have your due process considerations to be able to prepare for trial, we've got, like I said, good people that are out on the street and their liberty's not been restrained. They should be able to come to our office or at their own home and review their records and documents and discovery.
All right, thank you.
Glenn McKinley on behalf of Edwin Rodriguez. Your Honor, I echo my co-counsel. We've obviously spoken and
Right.
agreed to the same arguments. I would just reiterate, Your Honor, that it is completely unnecessary, the protective order. There's absolutely no need for it. There's no threats, there's no violence associated. And this is just not the case that we need to have the restrictions that would result in a logistical nightmare of getting the client to come and do the mountains of evidence that the government says that they have. So for all those reasons that were presented to the court, both here and sidebar, we would object to the protective order.
All right.
With respect to the statement of case, Your Honor, I also would like to note my objection to that as well. I believe that has nothing to do with the bail determination by the court, given the fact that the counsel for the government has indicated that there was no request for bail, it's a request for personal recognizance. In fact, noteworthy is the first line of the statement of case in which the Commonwealth indicates that it was being offered and filed for the purposes of the court's edification only. Well, quite frankly, I don't think that's a sufficient basis for putting those materials into the public domain. In particular, Your Honor, we have not been provided discovery. Had we been provided discovery and they sought to file this a month from now, we could have responded with our response to the Commonwealth's statement of case. We are unable to do that because we're literally just getting discovery today. So I would suggest it's unfair. It's unfair to put that information out there. I'd ask it to be filed under seal.
All right. I understand the objections of defense counsel, and certainly some of them are well-founded. Public has some right to know what's going on in this case. After balancing that right against the defendant's right to a fair trial, which is ultimately my goal here, obviously, I think it is appropriate in a case of this interest to have some statement of the case filed. As I said before, it isn't binding, it isn't evidence, it won't be used at trial. And I didn't find it to be inflammatory in any way. So I am going to allow it to be filed over defense counsel's objection. With regard to the protective order, I am going to endorse the protective order. It is appropriate. Again, at this point, counsel makes reference to being hamstrung for a year. I am not expecting the protective order to remain in effect as it is for a year. But as we just stated, you're just getting discovery. Court hasn't seen discovery. It doesn't know what's in there or not in there. It might be relevant to the protective order. Protective order helps to ensure, again, that there'll be a fair trial. Certainly I have experienced counsel here who knows how to handle a protective order. I have troopers here who hopefully have some experience, and I assume have some experience with handling evidence. But this is a case in which other people, family, relatives, friends of troopers, or other people may not handle the evidence with the same degree of care that the participants would, and I have some concern about that. I also want to indicate this is a temporary order. As defense counsel gets discovery and has more specific objections about some specific individual or individuals that the defendants are not allowed to contact or be in touch with, we can address that at that time. At some point, obviously, these restrictions may be loosened as the case becomes more specific. So that is only being imposed at this time until the next hearing date. I'm also imposing it on the counsel for Officer Lamont, who isn't here today. But again, in order to protect the rights of everyone, I will impose that order until that arraignment is done. All right, over the objection of defense counsel. All right. Is there anything else we need to address? We need another date.
I have to be available.
Yes.
To each individual, you are released on PR with the following conditions: to have no contact, direct or indirect, with any potential witness in the case. The list will be provided to the Commonwealth, and this list will be impounded. Is that correct, Judge?
Yes.
And that's without prejudice. To each defendant, you are hereby notified that if you fail without sufficient excuse to appear in court after being released on recognizance, may be punished by a fine of up to $10,000 or imprisonment for a year, both in the case of misdemeanor, and in the case of a felony, be fined up to $50,000 or imprisonment for 5 years, or both. Do you understand that to each defendant? Yes? Yes. Yes? And you are further notified that if you are charged with a new crime during the period of your release, your bail may be revoked and you may be held without bail for a period up to 90 days. Does each defendant understand that?
Yes, Madam Clerk.
And do we have a next date? And probation's gonna need to see each one of them before they leave today. Mr. Laughlin, right?
Yes. Your Honor, I'm just asking that the prosecutor provides the probation department with that list.
I
as
have the
well.
list.
You have the list.
All right. I'll be done.
I know, but it's not again. Friday, Monday. June 16th, Madam Clerk?
For pretrial conference, yep.
Yes.
June 16th, and probation then needs to see one downstairs. Please report to probation on the first floor before you leave.
The our clients be excused from the initial trial, or does this?
Any objection to that?
None, Your Honor.
They may be excused for the initial pretrial.
Thank you. June 17th. Yes, yeah. I have that list. June 17th, yeah.
All right.
16th, right. June 16th, yeah.